My name is Elena Sassauer, and I am the director and co-founder of the Center for Judicial Accountability, Inc., a nonpartisan, nonprofit citizens organization dedicated to safeguarding the public interest in judicial selection and discipline. I appear today in strong opposition to Senate confirmation of Governor Patterson's appointment of Appellate Division First Department Presiding Justice Jonathan Lippman to the New York Court of Appeals. CJA's opposition is on multiple grounds. One, Justice Lippman's appointment is the product of a corrupted merit selection process. Two, Justice Lippman's official misconduct as Chief Administrative Judge. Three, Justice Lippman's official misconduct as Appellate Division First Department Justice. Four, Justice Lippman's disregard of the public's welfare by his deal-making to become a Supreme Court Justice, his stepping stone to becoming the Appellate Division First Department's presiding justice. This committee, purported to look into the merit selection process that produced Justice Lippman's nomination by two hearings held on January 27th and February 3rd. I testified at the first of those hearings. However, none of this committee's members, except for Chairman Sampson, was present for my testimony or for the testimony of another good government judicial activist, Kevin McEwen. According to Senate Judiciary Committee Counsel, the hearing transcripts are not yet available, at least not to the public. Nor is there a committee report identifying, let alone evaluating, the information and evidence that I and Mr. McEwen presented and proffered with our testimony.
Just want to correct you on that, Ms. Sassauer. The hearings have not been completed yet, and we have two more hearings, one in upstate New York and Buffalo, and one downstate. And once we complete those hearings, a report will be ready, and the information you were provided will be in that report. Point of correction, that's all.
I will come back to that. Thank you for that clarification. Nor is there a committee report identifying, let alone evaluating, the information and evidence that I and Mr. McEwen presented and proffered with our testimony, or that had been presented and proffered to the Senate Judiciary Committee by other members of the public, most notably William Galison, who was not even given notice of either hearing or indeed of the hearing today, although he is present to testify. That evidence establishes the corruption of the constitutionally ordained merit selection process that has produced Judge Lippman's nomination. Such renders his nomination unconstitutional and a nullity as a matter of law. His confirmation cannot lawfully take place until this committee releases its findings with respect to that evidence, which to date it has not even investigated.
Ms. Sassauer, I just want to, I know you prepared your speech, but I want to get to the question. I want to ask you a couple questions. You're talking about corruption, misconduct as the deputy administrative judge, misconduct as the appellate division, and disregard for the public good. Could you cite to this committee examples of those points?
Absolutely.
Okay.
To begin, I would like to use the rules of the Chief Administrator,
okay,
which are published by the annual report of the Commission on Judicial Conduct. Mr. Tembekian is here, its administrator. Disciplinary responsibilities, administrative responsibilities. It identifies that a judge, certainly a judge in a position of supervision, has mandatory duties to ensure the integrity of the operations of the court, judicial personnel, staff, lawyers who are officers of the court. With respect to your first question, as to Justice Lippman's official misconduct as Appellate Division First Department Justice. First, let me identify and congratulate you for asking. But that question needed to be asked by the Commission on Judicial Nomination before he was nominated. One of the problems with the Commission on Judicial Nomination is that it is not conducting appropriate investigations of the qualifications of the candidates that it purports to be screening.
No, Ms. House, we can take up that, but I want to get, this committee, we want to get specifically. We want to get to the tangible evidence that you have.
Specifically,
Yeah, exactly.
he was on a variety of occasions given notice, written notice, and I have brought it here today, of misconduct by his own counsel at the Office of Court Administration with respect to approving financial awards that were inappropriate, with respect to the corruption of the Commission on Judicial Conduct, on which merit selection, the integrity of merit selection requires a functioning Commission on Judicial Conduct, as well as a functioning system of attorney discipline. He was given notice, written notice, of the dysfunction, of the corruption of the Commission on Judicial Conduct being covered up, being protected. He was called upon to use his powers and his duties to take appropriate steps. Likewise, Chief Judge Kaye, they did nothing.
All right.
Additionally, with respect to fiduciary appointments, as far as patronage and servitors, receiverships, these are matters that are already regulated, have long been regulated. The problem is, it's like judicial ethics. It's like attorney ethics. There is no enforcement. And the enforcement is at the top. Mr. Galison will be testifying specifically as to Judge Lippman's misfeasance, malfeasance, nonfeasance with respect to his important supervisory duties as Appellate Division First Department Justice. Let me just in conclusion say,
Okay.
when the people of this state relinquished their right to elect judges of the Court of Appeals because there was supposedly a better way, and it was called merit selection, what they were not told was that the following year the legislature would encapsulate the process in confidentiality and keep them out so there was no way to verify what was taking place. There are only two access points in the process as currently exists and has existed all these years. The first is the Commission on Judicial Nominations report to the governor of nominees. That is deficient, and the Commission on Judicial Nomination this time round tried to do a redo, but that report is deficient. The second access point is this hearing. This is the only real opportunity that the public has to hear and be heard. With all respect, Mr. Chairman, 5 minutes, there's no, what's the rush? What's your hurry?
Ms. Sasso, I understand, but thank you very much.
Thank you.
Thank you very much.